Honours, ladies and gentlemen, good evening. In this UNESCO Year of Indigenous Languages and acknowledging the Yagara and Turrbal peoples who by tradition are the custodians of these lands, I should say probably Wanya and Kulang Nurundai. These proceedings are being live streamed to audiences in courthouses in Cairns, Mackay and Rockhampton, and I welcome all those watching and listening. It's my happy task to welcome you to the Banco Court on this crisp autumn afternoon for the third Atkin Lecture. This is an annual series named in honour of James Richard Atkin. As many of you know, Atkin was born very close to us in the family home in Tank Street, Brisbane in 1867. In time, he would marry a Brisbane girl, Lucy Elizabeth Hemmant, pursue a highly successful legal career, and as Baron Atkin, Lord of Appeal in Ordinary, he would reunite the common law and St Luke's Gospel in the famous House of Lords decision of Donoghue and Stevenson. Our guest speaker for this year's Atkin Lecture is Professor Paul Brand. He did not have the good luck to be born in Queensland like Lord Atkin. His birth was in London on, of all days, the 25th of December. However, he has overcome the annual misfortune of a birthday subsumed by the celebration of Christmas. Professor Brand was educated at Hampton Grammar School in Middlesex, where he was, I think, a year ahead of Brian May, a founding member of the rock band Queen. Like Lord Atkin, Professor Brand was an undergraduate at Magdalen College, Oxford. He took a degree in history from Oxford University during the swinging 60s, and he continued with postgraduate studies and was awarded a doctorate by the university. He was assistant keeper at the Public Record Office in London, then a lecturer in law at the University College, Dublin, and in 1983, Professor Brand became, by choice, a private researcher based in London, working and writing on English legal history. In 1997, he was elected a Fellow of All Souls College, Oxford. In 2001, he became a Senior Research Fellow at the college, and in 2011, Senior Dean. In 2014, on retirement, he was elected an Emeritus Fellow. From 2010 to 2014, he was a Professor of English Legal History at the University of Oxford. He has held visiting professorial positions at the Columbia University Law School, the Arizona State University, the University of Michigan Law School in Ann Arbor, and at the University of Melbourne. Professor Brand is a Fellow of the British Academy, as Lord Atkin was. He is also a Fellow of the Royal Historical Society and a member of the American Law Institute. He's been a member of the Council of the Selden Society since 1990 and has served as Vice President since 2002. In 2014, he became an Honorary Bencher of the Middle Temple. His publications include The Origins of the English Legal Profession, The Making of the Common Law, and Kings, Barons and Justices, The Making and Enforcement of Legislation in 13th Century England. Professor Brand was a lead investigator on the 3-year AHRC-funded Magna Carta project, and in 2015 he presented papers related to that research at the High Court of Australia, Melbourne University Law School and the Australian Academy of Law. We very gratefully acknowledge the role of the University of Southern Queensland School of Law and Justice in bringing Professor Brand to Australia and so creating the opportunity for him to deliver this, the third Atkin Lecture. Professor Brand's topic tonight is Rhetoric and Reality, the Making of English Medieval Legislation. Would you please join with me in making him welcome?
Well, I was promised that I would be reminded of some things that I had forgotten in that introduction. That was indeed true. There were things I had entirely forgotten. It's nice to hear them. I'm also reminded that I need to do the PowerPoint. The King's ability to make, publish, and enforce legislation was a significant part of his governmental power in England in the later Middle Ages, because of the degree of control which this allowed the king and his government to exercise over the whole of the king's subjects. The king had and exercised on a regular basis the ability to create or alter generally binding legal norms, with few significant restrictions in terms of subject matter. And in that, he was really quite different even from the King of France, who could do very little. And also to establish mechanisms for their enforcement, including penalties for their infraction. He possessed, in the network of royal courts and the framework of local government, with county sheriffs and their subordinates to execute the king's orders, and the communal court system in counties, in hundreds and wapentakes, to provide an effective nationwide local machinery for ensuring their enforcement. Legislation was also one of the few ways in which kings were able to demonstrate their practical utility to the mass of their subjects on anything like a regular basis. It was a significant mechanism for evoking, earning, and retaining the loyalty of the king's subjects, and for fostering their attachment to the monarchy, because legislative power allowed kings to offer general remedies for their subjects' grievances, and a means of creating and enforcing new rights for them as tenants against their lords, sometimes for lords as against their tenants, and perhaps as importantly, for them against their neighbours. In what was still a largely oral world, the publication of legislation through public proclamation in the localities took on a special importance. It was not just a way of ensuring that those affected by legislation were made aware of new rules they were going to be required to observe for the future, and new mechanisms created for their enforcement, but also an important channel through which the king communicated directly with his subjects. Kings needed to explain why legislation was desirable or necessary, and also to claim the credit for its enactment. And the rhetoric of written legislation, more specifically of legislative drafts, though this often survived to form part of the legislation as finally enacted, also typically had another important purpose. The king could probably enact and publish some specific types of legislation on his own initiative without the need for wider consultation or consent. But for most legislation, even if the legislative initiative in this period lay with the king and his officials and close advisors, there was an expectation that before it was promulgated, the king would have taken the advice and obtained the consent of a wider group of his greater and more powerful subjects, the lay magnates or barons, and the members of the higher clergy, bishops, and also abbots and friars, and later from Parliament as a whole, which by the later 13th century had normally, but not yet invariably, come to include, in addition, representatives of county communities and of cities and towns from all over England. This was no mere formality, and the discussion of legislation might lead to major changes in legislation before it received approval. Some of the rhetoric which legislation contained seems to have been inserted in order to obtain the approval of members of this group as well. What this paper does is to look at the rhetoric of some of the legislation enacted during the 13th century. This was a period which saw the enactment of a considerable volume of legislation, which had a major and continuing impact and importance. Indeed, it was so important that when the fledgling Inns of Court in London began to provide lectures on major legislation for law students, from perhaps as early as the middle of the 14th century, the statutes covered in the lectures were for a long time only these classic older 13th and early 14th century statutes, beginning with Magna Carta, running through to De Conjunctim Feofatis, those jointly enfeoffed of 1306, not any more recent ones. What seems to me to be clearly observable in the rhetoric of the legislation of this period is the desire to present matters in as favourable a light as possible, to take credit for things that can be quite misleading. It's misleading both about the past, that is to say about events which had taken place prior to the enactment of the legislation and the reasons for the enactment of the statute, even about how new a particular statute or some of its contents were. But also about the future, about what the legislation itself was intended to achieve and the effect it was intended to have. I will start with the first of these. The Statute of Marlborough was enacted in November 1267. This was not long after the conclusion of a civil war between Henry III and his magnate opponents. Those opponents had been led by Henry's own brother-in-law, Simon de Montfort, Earl of Leicester, who had met his death at the Battle of Evesham in the summer of 1265, though it had taken another 2 years before peace had been fully re-established in England. The statute gives every appearance of being a carefully considered response to the disorder associated with the recent civil war and its aftermath. Its preamble describes England as a country which had recently been disturbed by tribulations, harmed by dissensions, and which therefore needed a reform of the law in order to ensure the peace and tranquility of its inhabitants. It talks of the king and his lieges, in this context the King's Council, as supplying that necessary remedy through the provisions, ordinances, and statutes which followed. There then follow 4 chapters which do indeed look to be specifically concerned with problems which had arisen during the recent period of disturbances. Magnates and others were not in future to seek extrajudicial redress for supposed wrongs, or to pressurize those not under the jurisdiction of their courts to come and answer for such wrongs, as they had recently been doing. Nor were they to resist the proper execution of the process of the King's courts, or to violate legal restrictions on the use of distraint, the seizure of movable goods. Punishments were threatened if these rules were broken. The 25 clauses which follow are not so obviously related to recent events, but the preamble certainly suggests that they too are part of a general overhaul of the law made necessary by recent events and experience. There is nothing anywhere in the statute to give even the slightest of hints of what is actually the case, that all except the first 4 of the remaining 25 chapters of the statute are a final revised version of legislation first enacted 8 years earlier, in October 1259, when it had been known by a different name as the Provisions of Westminster, with some omissions and additions made for the reissue of those same provisions in 1263 and 1264. The original context of a major part of this legislation is therefore not, as it seems to be, the aftermath of civil war and the related disturbances, but the very different circumstances which had obtained in 1259, not long after a baronial council with a reforming programme had taken over governmental power in England. These provisions had originally been enacted as part of that programme, and we have various surviving prior drafts of those provisions, including, exceptionally for 13th century legislation, a published draft of part of the provisions. And there must be some doubt about even the first 4 chapters of the statute being quite so closely tied to the disorder of the Civil War, now that we know that a first draft of part of these provisions goes back to a relatively newly rediscovered by me draft of part of the provisions of Westminster, which apparently belongs to the June Parliament of 1259, not to 1267 at all. This was not the first time that those drafting legislation in the name of Henry III had deliberately ignored the prior existence and indeed prior enforcement of legislation when they issued what was apparently original legislation, but which in effect simply confirmed legislation already in existence. In May 1262, after resuming control of the administrative machinery of royal government from his baronial opponents, Henry made an ambiguous repudiation of the work of that same baronial council. That had left it unclear whether or not the repudiation extended to those same provisions of Westminster of 1259. Half a year later, in January 1263, Henry reissued the provisions in a lightly revised and extended version, but with a new preamble. That gave no hint that the legislation which followed was anything but entirely new. Only someone who knew the previous legislation well would have noticed just how carefully the revised preamble had been drafted to spell out the king's view of the legislative process and his preeminent place in it. The preamble tells us that in the year of the Lord 1262, in the 47th regnal year of the Lord King Henry, the son of King John, of the mere and free will of the same Lord King, and in the full and free power of the same, with the stimulus of the council of his subjects, the constitutions that follow were issued by the same Lord King for the reformation and improvement of his kingdom, and published by him, ordered to be observed generally by his authority. This was in tacit but deliberate contrast to the view of the reforming council enunciated in the 1259 provisions, which stated the legislation had been made by king and magnates, by the common counsel and consent of the king and the magnates. The omission of any reference to the earlier legislation is explicable in the case of the 1263 reissue by Henry's own view of the 1259 provisions. For Henry, they were evidently null and void, something to which he had only consented under duress. It was therefore only in 1263 that the legislation in its new revised form was, for the first time, properly coming into effect. But that wasn't the case in 1267. Indeed, it was the king's own prior voluntary acceptance of the provisions in 1263 which helped to ensure their survival. For one of the recommendations of the committee appointed at the Kenilworth Parliament of 1266 to assist in the general process of conciliation was that the king continue to observe the concessions which he had made spontaneously and without coercion, and also confirm on a permanent basis other necessary measures devised by his men with his agreement. That clearly included the 1263 reissue of the provisions. But the wounds to the king's dignity left by the period of baronial reform, and perhaps also the fact that the 1263 reissue had been followed by a further reissue of the provisions in 1264, during a period when Henry III was a virtual prisoner of his own brother-in-law, Simon de Montfort, seemed to have ensured that the king deliberately avoided any reference to the 1263 reissue, even as he reaffirmed its substance. Contemporaries who knew the earlier legislation would not have been fooled. But within a generation, as knowledge of the earlier legislation was lost, as lawyers and others copied the later legislation but ceased to copy the earlier, this will have ceased to be the case. A different kind of distortion of the immediate past is to be found in the preamble to the Statute of Mortmain of November 1279. This stated that it had been enacted sometime previously that the religious, that is to say, religious houses of any kind, abbeys, priories, nunneries, colleges, hospitals, were not to enter the fees of anyone, that is, acquire lands or other kinds of real property from any tenant, any holder of those lands, without the permission and against the wishes of the lords of whom that property was held, but that despite that prohibition, the religious had subsequently continued to enter not only their own fees, something which of course had not been covered or caught by the legislation, but also the fees of others, land held of other lords, appropriating and buying them, sometimes receiving them by way of gift. It also went on to allege the unfortunate consequences of this continued acquisition of property by the religious, both for the overall defence of the kingdom and through the losses that this caused to lords. It was this non-observance of the earlier legislation which was then cited as the justification for the new and more drastic legislation, totally prohibiting all future grants of land to the church, to which I will return. There had indeed been earlier legislation in much the terms cited by the Statute of Mortmain. It had been part of the original provisions of Westminster of 1259, of which it had formed what is now known, though there was no original enumeration of clauses in this or other legislation of the period, as Clause 14. But when the provisions were reissued by Henry III in 1263, this clause had apparently deliberately been omitted from the reissue. It had not been reinstated when the provisions had been reissued a second time in 1264, or even a third time in 1267, as part of the Statute of Marlborough. It's not entirely clear whether Edward I and his advisers actually knew that there was no valid legislation in existence requiring the consent of lords to any alienations in mortmain made by their tenants. 2 years earlier, in 1277, the Abbot of Croxton in Leicestershire had been summoned to answer Robert Luttrell in the Common Bench, the main civil court at Westminster, as to why, whereas it is contained in the provisions of Marlborough that the religious are not to enter the fee of anyone without the permission and agreement of the chief lord of that fee, namely the lord of whom the property is immediately held, he had nonetheless entered land, in a very substantial holding, held of the plaintiff by Philip de Ghent, without the permission and agreement of the same Robert and against the terms of the same provision. This seems to indicate that the King's Chancery had, by 1277, begun to suppose that a clause similar to that which had been in the provisions of Westminster had indeed formed part of the statute, here called the provision, but clearly the statute of Marlborough, and was willing to issue a writ for a litigant for breach of its provisions. No pleadings have been found in the case. It seems probable that it was settled out of court. In a second case from the Yorkshire Eyre of 1279-81, prolonged visitation of the county by royal justices, but one that was almost certainly heard in Trinity Term 1279, brought by Roger Dyville against the Master of the Templars and one of his brothers, the defendants were summoned to answer why, whereas it has been provided by the Common Council of the realm that the religious are not allowed to enter the fee of anyone without the permission and agreement of the chief lord of that fee, they had entered land at South Cave, held of the plaintiff, without his permission and agreement. No particular statute was mentioned in this case. This time, the writ certainly didn't go without challenge. The defendants objected that no such legislation had ever been published by the present king or his ancestors. The justices, however, advised the defendants to answer over. Writs of a similar form had been previously issued by Chancery, and that indicated that they had received royal approval. The defendants, however, continued to object to the writ, saying that they understood that the princes and magnates of England had never agreed to such legislation, nor to its publication. And that, of course, wasn't true. What was true was that the legislation had been issued, but had been repealed. They refused to answer the writ until the king's wishes in this matter were known. But before judgment could be given, the parties reached a settlement early in 1280 at York, under which the defendants were allowed to retain the land, but they had to pay £40, a very substantial amount of money, for this permission, and also to agree to hold the land directly of the plaintiffs. The chronology suggests that it may even have been the discussion of this second case by the King's Council at the Autumn Parliament of 1279, which led on to a wider discussion of the continuing problems caused by mortmain alienations and thus to the enactment of the Statute of Mortmain. It's a little difficult to believe that neither Edward I, who had certainly been present at the enactment of the Statute of Marlborough, as the preamble to that statute itself mentions, nor his advisers, many of whom had probably been there too, really didn't know that the statute didn't contain the clause about mortmain alienations. And there was certainly at least one contemporary official text of the statute in official custody in the Red Book of the Exchequer, part of the archive of the Exchequer, which could have been consulted and would have given the correct answer. But perhaps, fallible as always, they simply relied on their memories and assumed that everything that had been in the original provisions of Westminster had also been incorporated in the Statute of Marlborough. This was in general true, only untrue of this particular clause. They may not have been deliberately intending to deceive, but nonetheless have ended up doing so. Legislation may also mislead us and may sometimes have misled contemporaries when it appears to suggest the existence of a general and well-known socio-legal problem, but seems actually to have arisen out of the consideration of one particular set of facts, as revealed by a single piece of legislation. The best example of this known to me is one of the two parts of Chapter 6 of the Statute of Marlborough, one of the clauses which were added when the provisions of Westminster were reissued in 1267. This purports to be concerned with the problems created by a device used by tenants wishing to create secure leases, which would not be interrupted by a wardship if one occurred when the lessor was a tenant holding by knight service and he died with only an heir under age to succeed him, and so his lands, including land he had leased out, fell into the wardship of the lord of whom he held them. As the statute explained it, tenants wanting to lease their lands for a fixed and secure period of time made what was in form a permanent grant of the lands being leased, reserving services for the period of the lease, but stating in the grant that these had been performed or paid in full for this period. The grantor or lessor reserved services greatly in excess of the value of the land, so as to ensure that the lessee really did surrender the land at the end of what was intended to be the period of his lease. Such a conveyance was on its face a permanent grant, so the lessee during his term had all the rights of a tenant in fee, a full property owner, including the right to secure tenure of the land during the wardship of the lessor's heir, as well as the protection of the freeholder's remedies against other kinds of dispossession. But at the end of the term, the land would be certain to revert to the lessor or grantor, just as if the conveyance had been a lease. The statute suggests that such leases posed a general problem for lords because they were made in order to ensure that the lords of fees lose their wardships. There is, however, little evidence to suggest that fiefments of this kind had become at all common prior to 1267. Indeed, the only evidence I have found of their existence and use prior to 1267 comes from a single case which had been heard in the Common Bench at Westminster a little over 5 years prior to the enactment of the statute. It was an action of dower which had been brought by Isabel, the widow of William of Milding, against Urien de St. Peter for her dower third of an extensive holding at a particular place in Leicestershire. And by Hilary term 1262, Urien had vouched Peter, the son and heir of the widow's husband, to warranty, requiring him to take over the obligation to meet and satisfy the widow's claim or to contest it. Peter was underage, and he was in the wardship of the king's chancellor, Walter of Merton, who held this wardship by the king's grant. Walter sought the king's assistance in contesting the supposed obligation of warranty. And the king's sergeant, Lawrence del Brock, the king's lawyer acting on his behalf, then asked Urien to show how and why the heir was obliged to provide warranty. Urien, or probably his sergeant, produced the deed by virtue of which he held the land, and under which William had promised Urien warranty on behalf of himself and his heirs. The deed is reproduced virtually in full in the enrolment. It corresponds in almost all respects to the form of the grant mentioned in chapter 6. William purported to grant his manor of Dadlington to Urien for life, for a rent of £40 a year, but stated in the grant that he'd already been paid the whole of the rent for the first 15 years, reserving only half a mark a year, relatively small sum, still to be paid each year, and that the £40 was only to be payable after 15 years, or, in the case of unforeseen interruptions, after Urien had received 15 crops from the land. William had also built in a specific condition for the reversion of the land if Urien failed to pay the additional rent after the receipt of the 15 crops. Since the lands weren't worth anything like £40 a year, this was essentially a 15-year lease, but one which took the form of a life grant. The king's lawyer, Lawrence, objected to the contradictory nature of the deed. It was in form both a life grant and a lease for 15 years, plus a right to extend the lease for the lessee's life. He argued that its inconsistencies meant that it was insufficient in law to oblige the heir to warranty. It was therefore also insufficient to oblige the king, as the warrantor of his guardian, to warranty. The case was adjourned for judgment. Before judgment was given, the case was referred to and discussed by the king and his council, evidently just after it had been heard. Their decision, as communicated to the justices of the Common Bench by a royal writ issued in late February 1262, authorised by the king and the whole of the council, was that Isabel should be given her dower from the lands held by Urien. They adjourned for further consideration and definitive judgment on whether or not Urien was entitled to his warranty, and thus to an exchange of lands of the same value from the king. It can, I think, be no coincidence that this case involved a fictitious fiefment of almost exactly the same form as that mentioned in the legislation, that the case involved not just the king, but also one of his leading servants and councillors, Walter of Merton, then Chancellor, and eventually founder of Merton College in Oxford, and that the case had evidently led to conciliar discussions about the validity of such fiefments, whether they should be allowed to deprive lords of their rights of wardship, and that the king's writ to the justices specifically mentioned the possibility that if deeds of this kind were to be allowed, the king and other chief lords might be fraudulently deprived of their wardships. It didn't lead to legislation in 1262, perhaps because there was some continuing doubt and discussion about whether such deeds should be treated as wholly void or as voidable only in as far as they attempted to deprive the lord of his wardship, though valid as against the grantor and his heirs once they came of age. For much of the intervening period, the council was perhaps too busy with other matters to discuss it further. But there are good reasons for supposing that it was this case, and this case alone, which led to the drafting and approval of the second part of Chapter 6 of the Statute of Marlborough. There is no other evidence to suggest that such feigned fiefments had become common, or that they posed any significant threat to seigneurial income from wardships. It wasn't a general social problem. And there are, in any case, good reasons for supposing that for the lessee, perhaps also for the lessor, the main point of the arrangement, and other such arrangements also found later, was to give the lessee the additional security of the freeholder against dispossession during the lease, whether by the lessor or by a third party, through the assize of novel of the season, when the lessee's normal remedies against dispossession were slower and much less effective. It seems unlikely that most lessors were sufficiently pessimistic about their own chances of survival to have gone out of their way by using this particular device to ensure that their lords did not enjoy the benefit of wardship of their lands. The Statute of Mortmain, already mentioned for its misleading account of the background to the statute, was also misleading in another and even more fundamental respect. The statute purported to prohibit all alienations in mortmain, all permanent grants of land and other kinds of real property, not just to religious institutions, who had been the only targets of the 1259 legislation, but also all other kinds of ecclesiastical tenant, so including bishops, canons, even parish priests and their successors. Any attempted infraction of the prohibition was to render the property concerned liable to forfeiture. The immediate lord of whom the property was held was to be allowed a year to take possession of the property. If he failed to do so, each of the superior lords, the lords above him in the tenurial chain, were in turn given 6 months to do the same. The statute states also gives the king a right of entry if all the other lords failed to do so. But this had to be at least a year after the initial grant. In practice, however, within 6 months of the enactment of the statute, the king began to grant licenses to allow individual alienations in mortmain, grants in mortmain, notwithstanding the provisions of the statute. Grants to ecclesiastical institutions and office holders were allowed to continue, but each now required royal permission. This came to be granted only after a preliminary investigation as to any potential harm from the grant, through an inquisition ad quod damnum, an inquiry as to what harm. After evidence that the immediate lord had himself consented to the grant, and written evidence of that, and after the King's Council and the King himself agreed to the grant, but only as from 1299, that is almost 20 years after the enactment of the legislation, after payment for the King's license. The shortness of the period of time between the enactment of the legislation and the issuing of the first licenses suggests that a licensing scheme must always have been intended, and that it had never really been intended to stop all mortmain alienations. But if so, why was the legislation enacted in this form? The noted English legal historian, Theodore Plucknett, writing in 1949, thought that it was all a trick on the part of the king. The lay lords thought they were assenting to legislation prohibiting all mortmain alienations, when they were merely paving the way for the king to exercise the sole prerogative of amortization and acquiring a new source of income from doing so. The rhetoric of the King's statute was all about a total ban on mortmain alienations. The underlying reality was that the king wanted to gain sole control of amortization for himself and to profit from doing so. In 1968, Malcolm Bean suggested that the statute had a rather different purpose. Its immediate and successful purpose was to bring the clergy, more specifically Archbishop Petcham of Canterbury, to heel at a time of major tensions between church and state. And it was retained, he said, in tandem with the system of licensing rather than repealed, because the potential threat of a blanket refusal of licenses was a useful weapon to hold in reserve against a potentially recalcitrant clergy. But there are good reasons for supposing that both these views are mistaken. The lay lords who agreed to the legislation were the same group who were then involved in discussing and agreeing individual mortmain licenses. The king was certainly not going behind their backs in issuing licenses. Nor did the king obtain a sole prerogative of amortization under the licensing system, since from 1285 and possibly even earlier, mortmain licenses were only issued after the immediate lord's written agreement to the acquisition had been produced. And it was almost 20 years before the king began to charge for licenses at a time of financial crisis. That hardly suggests that the new stream of income had been the first thing on the king's mind in 1279. And if the statute was intended, as Bean suggested, to be a threat to the clergy, it's difficult to see why Edward I went ahead with the statute on the 14th of November, when the supposed immediate purpose, ensuring the withdrawal of certain decisions of Petcham's first provincial council, supposedly prejudicial to the crown, had been achieved a few days earlier between the 9th and 11th of November, and when the clergy was able to go ahead only 2 years later with reenacting 3 of the 5 canons withdrawn by Patcham in 1279 without any reimposition of the blanket prohibition. And also why Edward didn't use it as a threat in the 1290s at the time of further fundamental conflict over the king's ability to collect taxes from the clergy, even when he did for a period in 1297 place the whole of the clergy outside the king's protection, which in effect meant that they couldn't bring litigation in the king's courts. I'm not sure that the statute and its rhetoric were, in this case, even intended to mislead, though that's the obvious way to characterize them. The prohibition of mortmain alienations and provisions for forfeiture for its breach mandated by the statute performed and continued to perform 2 useful functions, even after the introduction of the licensing system, and even if these were not immediately apparent on the face of the legislation. The first was that they created the necessary preconditions for the subsequent but virtually immediate erection of a flexible licensing system. Because it was done in this way, through a total prohibition followed by license exceptions, the details of the licensing system and its operation did not have to be spelled out in the legislation and could be, indeed were, adjusted and developed over time. They could be operated with a considerable degree of royal discretion, though one generally exercised on the advice of his council. The second was that retaining the provisions for forfeiture helped in the enforcement of the requirement of a royal license. The threat and reality of seizures and forfeitures enforced both by lords and by royal officials in the case of unlicensed alienations ensured, for the most part, that grantors and grantees went through the licensing system, sought licenses before they went ahead with alienations in mortmain. But the relatively small number of seizures and forfeitures made by individual lords and by royal officials brought in a welcome stream of revenue for lords and the king, and reminded those wishing to make such grants of the virtues of complying with the requirements of the licensing system. And for the king and his officials, there was no clock running in favour of the unlicensed grantee. Seizures could be made however far back in time such an alienation had been made after the statute, and the grantee had to pay the king the interim profits of the seized property. The Statute of Mortmain is perhaps the most obvious 13th century example of what might be reasonably described as disingenuous legislation. Legislation whose rhetoric suggested it had one purpose, but which in fact had another and a rather different one. There are other possible examples of this phenomenon. One is the Statute of Acton Burnell of 1283 and its close relative, the Statute of Merchants of 1285. These 2 statutes established a system of local official registries for the recording of debts and harsh mechanisms, imprisonment of the debtor, compulsory sale of the debtor's movables, and, but only after the enactment of the second statute in 1285, turning over of all of the debtor's lands to the creditor until their profits had paid off the debt, to ensure repayment of debts so registered when they fell due. The preamble to the Statute of Acton Burnell justifies the legislation in terms of the hardships hitherto suffered by merchants who'd sold goods on credit and then found that their debtors did not pay up on time because there existed no mechanism to ensure the quick payment of debts. This had, it said, led to foreign merchants staying away from England with their merchandise, to the damage of domestic merchants and the kingdom as a whole. This seems strange, for the deficiency identified in the preamble appears to be one of long standing, but the statute's own rhetoric suggests there's some sort of immediate crisis for which legislation is required. The apparent concern of the statute with the needs of mercantile, especially foreign mercantile creditors, is also reflected by the way that its provisions start off by referring to the creditor registering his debt as a merchant, though after that the statute just refers to him as a creditor, and in special additional provisions made for the payment of the costs of foreign merchants staying in England until their debt was levied. It must be significant, however, that from the very beginning, no attempt was made to limit the use of the system to mercantile creditors. The only group debarred from using the new debt registries were Jews, who already had their own quite separate debt registries and had for over a century. And that it was from the first used by other kinds of creditor. It wasn't until 1311 that any attempt was made in ordinances to confine its use to merchant creditors, and indeed to further confine its use to merchant debtors as well. But those restrictions were no more than temporary and were repealed in 1322. That suggests that from the beginning the king and his advisors had no intention of confining its use in this way, had always intended that others should have access to it. There's some reason for supposing that the whole scheme may have been the brainchild of the Chancellor, Robert Burnell. And it may be no coincidence that the initial scheme, that made in the Statute of Acton Burnell, made Chancery rather than the courts the essential link in ensuring any enforcement of the debt outside of the towns where the debts were registered through arrest and imprisonment of debtors and seizure of their movables. Burnell perhaps also had in mind the creation of a more efficient and reliable way of recording debts and enforcing their payment, which would capture this business for the king's administration at the expense of towns and cities and their local courts. It might be going too far to say that the drafters of the Statute of Acton Burnell had no real interest in assisting foreign merchants in securing quick repayment of their loans, including payments for goods sold on credit. But it may also be that their plight was a useful pretext for the enactment of a scheme which was from the first intended to cater for a much broader clientele. The Statute of Merchants of 1285, enacted less than 2 years later, is also disingenuous, but in a different way. Its preamble starts by touting the success of Acton Burnell and claiming that since its enactment, merchants had been able to recover their debts with much less trouble, but also said that these merchants had complained that sheriffs had been misinterpreting the statute, maliciously delaying execution under its provisions. This had, it says, led to the king having the provisions of Acton Burnell read out, probably at the Easter Parliament at Westminster where the statute was enacted, then making this legislation to clarify certain of the articles of the statute. In practice, the statute was much, much more than this. It was a thorough reworking and revision of the Acton Burnell scheme for the registration and enforcement of debts. Acton Burnell had established debt registries in just 3 major towns, London, York and Bristol. But even before the Statute of Merchants was enacted, registries had also been established in Lincoln, in Winchester and possibly in Shrewsbury. The Statute of Merchants specifically gave the king the power to establish them wherever he thought appropriate, in England and in the English Lordship of Ireland, and also at fairs. Imprisonment of the debtor under the Acton Burnell scheme was a last resort if all efforts to levy the debt from his goods in the town where the debt was registered and then outside had failed. Under the Statute of Merchants scheme, it was the very first step in enforcing payment. And with the debtor being given a grace period of a quarter of a year when he could sell his chattels and his lands to pay off the debt, despite the fact that he was in prison. And as has already been noted, it was the Statute of Merchants which for the first time specifically authorised the creditor to be given possession of all of the debtor's lands as valued to hold until he had recovered his debt, with this part of the process being reported back to one of the main central royal courts. It's difficult not to conclude from all this that the Acton Burnell scheme may from the first have been intended as a pilot scheme to see how well such a system would work, what changes might be needed to make it more effective. This is certainly how it worked in practice. Conclusions. This paper has demonstrated how important it is for the legal historian to read with appropriate caution, even skepticism, the contents of English medieval legislation, to be wary of believing everything it says. As we've seen, at first sight, the 29 chapters of the Statute of Marlborough appear to have been drafted as a response to problems associated with the aftermath of a period of civil war. But in reality, a majority of those chapters were a reenactment of legislation originally drafted under quite different circumstances 8 years earlier, when the baronial council was driving the drafting, approval and publication of legislation. In the preamble to the Statute of Mortmain, we see a rather different kind of distortion of the past, with its claim that a more drastic solution to the problems created by large-scale grants of land and property to religious institutions being made without the consent of the lords of whom such property was held was required in the light of disregarding of existing legislation, when the legislation cited was a clause of the provisions of Westminster omitted when those provisions were reissued. A third variety of implicit misrepresentation of the past, and one sufficiently convincing to have convinced several modern legal historians, is that found in one of two sections of Chapter 6 of the Statute of Marlborough, when it's concerned with the use of feigned fiefments as a way of making a disguised lease with enhanced protections for the lessee and the dangers that pose to seigneurial rights of wardship over land. The chapter makes it look as though such fiefments were common and a recurring problem for lords prior to 1267. However, as has been seen, the legislation seems to have been triggered by a single dower case of 1262, revealing the existence of a single such fiefment, but in a case involving the king and his chancellor, and in which the king was represented by the first known king's sergeant, Lawrence del Brock. The king's writ to the justices relating to this case reveals the fact that it raised concerns about potential harm to the king and other lords from the use of such a device, but it doesn't suggest that it had already become common, or indeed had been used by anyone other than Urien de St. Peter in this case. The paper has, I hope, also demonstrated to you how and why two pieces of 13th century legislation were deliberately misleading about their purposes and justification. The first is, again, the Statute of Mortmain, which, as we've seen, appeared to prohibit all future grants of land to religious institution and ecclesiastical tenants, and to have given teeth to that prohibition by providing that future grants would trigger the potential forfeiture of the property to an immediate lord or a superior lord or to the king. But the speed with which the first licenses were granted, the rapid development of an elaborate licensing system, suggests that a total prohibition was never the real intention behind the statute. And I've suggested that the threat of forfeitures was a useful way of ensuring that grantors and grantees went through the licensing system, and that starting with a blanket prohibition allowed for the gradual development of a licensing system to ensure that the system operated in the interests of all the main stakeholders, if I may use that modern term. But I think it actually covers quite nicely what this actually dealt with. When such grants were to be made, and allowed the king and his council to consider particular requests for licenses with a considerable degree of discretion. In the case of the statutes of Acton Burnell and merchants, which introduced the system for local official debt registries and mechanisms to compel payment, which was much harsher than those available even to Jewish creditors for debts registered in the Jewish chirograph chests, these measures were initially justified by the needs of foreign merchants for the swift recovery of their debts. But the new machinery was then the first available for any creditor. And it looks as though the whole machinery was intended to capture new business for the king's government at the expense of local towns and cities, and that the needs of foreign merchants were a good pretext for this more general measure. The 1285 Statute of Merchants purported to be no more than a clarification of Acton Burnell, but was actually a detailed reworking of the machinery established by the earlier statute. And I've suggested that Acton Burnell may always have been intended as a pilot scheme to be superseded in due course after changes that experience suggested were required. What I've been discussing in this paper all took place a long time, more than 7 centuries ago. And the legislation I've been discussing was drafted in Anglo-Norman French and enacted in that same language or in Latin. Their world was a very different one, when the monarch still exercised real authority and power, where the main form of property was land, and it was all held by its possession on feudal terms that had the tenant of that land hold of another, a lord, who exercised continuing rights over the land and over its tenants, when a significant proportion of that land was held by ecclesiastical institutions, when even Parliament was dominated by the great and lesser folk were only just coming to have their representatives in Parliament. But in some of the ways in which legislation was deliberately misleading in 13th century England, I can find echoes of what we still find in modern legislation in the United Kingdom. Whether that might also be true of Australia is a question a visitor would be wise to leave to his audiences. Thank you.
When I read the précis of your lecture, Professor Brand, I was quite attracted to the idea, and I thought there was much to recommend the drafting approach of Acts of Parliament that were intended to be read aloud rather than have to be read in hundreds and hundreds of pages. And I have to say it's somewhat disappointing to note that even in medieval times one can detect a significant gap between the rhetoric and the realities of legislation. But thank you for sharing with us some of the fruits of your historical research. And could I ask you to please accept on our behalf these gifts as a token of our
Thank you very much. I'm
moved.
I won't immediately open them, but
You will in due course.
I will in due course. And oh, yes, that looks very good.
This ends the formal part of this afternoon's lecture. The next event in the Selden Society lecture program will be held here on Thursday the 18th of July at 5:15 p.m. for 5:30, and on that occasion we'll be turning our attention to North America when Lionel Hogg will speak on Oliver Wendell Holmes and the First Amendment to the United States Constitution. But for now, would you please join us outside in the Portrait Gallery for some refreshments? Thank you.